In 2010, Otis McDonald lived in an area of Chicago that was prone to drug trafficking and gang-related violence. He'd been a victim of 5 burglaries, and he wanted to acquire a handgun to protect his home. But in an attempt to lower its high murder rate, Chicago lawmakers had long before outlawed the sale, possession, and registration of all handguns. In 2008, the Supreme Court had ruled in District of Columbia v. Heller that the Second Amendment to the United States Constitution protects an individual's right to possess a firearm for traditionally lawful purposes, such as self-defense within the home. But the ruling applied only to Washington, D.C., which is a federally controlled district and not a state. So in Chicago, Otis McDonald and 4 others sued the city of Chicago, arguing that the court should apply the same reasoning to the state and city.
Hi, I'm Doug Ginsburg, and I'm a federal judge. The case of McDonald versus Chicago tested the reach of the Second Amendment. McDonald and others sued the city, arguing that the handgun ban violated their Second Amendment right to keep and bear arms for self-defense within the home. Specifically, they alleged that the city's handgun ban left them vulnerable to criminals. They also argued that either the Privileges and Immunities Clause of the 14th Amendment or the Due Process Clause of the 14th Amendment makes the Second Amendment applicable to the states and their local government. The Second Amendment says, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." The Privileges and Immunities Clause of the 14th Amendment provides, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States." And the Due Process Clause of the 14th Amendment provides, "No state shall deprive any person of life, liberty, or property without due process of law." Whenever the Supreme Court has held a provision in the Bill of Rights applicable to the states, it has always done so through the Due Process Clause of the 14th Amendment. This is called the incorporation doctrine. The governing standard is whether that provision is fundamental to our nation's system of ordered liberty and our system of justice. The Supreme Court faced this question: does the Second Amendment apply to the states? And if so, is it because of the Privileges and Immunities Clause or because of the Due Process Clause in the 14th Amendment? Justice Samuel Alito reasoned that the right to self-defense is a fundamental right and is therefore applicable to the states and their local governments. He reasoned that the correct method to do that was using the Due Process Clause and the incorporation doctrine. After oral arguments and deliberations, the court voted 5-4 in favor of McDonald. Justice Alito wrote the majority opinion, in which 2 other justices joined. 2 additional justices concurred with different reasoning, and 4 justices dissented. Justice Thomas would have reached the same result pursuant to the Privileges and Immunities Clause of the 14th Amendment. The ruling confirmed that the Second Amendment right to keep and bear arms is protected not only against federal infringement, but also against infringement by the states. Using the incorporation doctrine and the Due Process Clause of the 14th Amendment, the Supreme Court has now made almost all of the rights in the first 8 amendments fully applicable to the states.
McDonald versus Chicago was decided in favor of McDonald by a 5-4 majority vote in 2010. The key principle was the Second Amendment and the Due Process Clause of the 14th Amendment. The Supreme Court held that the Second Amendment right to keep and bear arms for self-defense is applicable to the states.